Good afternoon, everyone, and welcome to our McLaughlin College Lunchtime Talks. And we always begin our lunchtime talks with the land acknowledgement. This meeting is virtual, and because of that, we are not actually gathered in the same space. York's land acknowledgement might not represent the territory that you are currently on. And I would ask that if this is the case, that you each take the responsibility to acknowledge the traditional territory that you are on and its current treaty holders. As a member of the York University community, I recognize many Indigenous nations have longstanding relationships with the territories upon which York University campuses are located that precede the establishment of York University. York University acknowledges its presence on the traditional territory of many Indigenous nations. The area known as Tookarondo has been caretaken by the Anishinaabe Nation, the Haudenosaunee Confederacy, the Huron-Wendat, and the Métis. It is now home to many Indigenous peoples. We acknowledge the current treaty holders, the Mississaugas of the Credit First Nation. This territory is subject to the Dish with One Spoon Wampum Covenant, an agreement to peaceably share and care for the Great Lakes region. Thank you for joining our McLaughlin College lunchtime talks. Today we're launching, of course, the new edited volume on Terrorism and Asylum, published by Brill Ninehoff, that was just released actually a few days ago. It consists of 11 original chapters and an introduction and conclusion, of course, that examine and explore the various permutations and connections between these two very significant terms in today's lexicon, terrorism and asylum. The latest UNHCR report on global trends, Forced Displacement 2019, states that there are 79.5 million forcibly displaced in the world today as a result of persecution, conflict, violence, human rights violations, or events seriously disturbing the public order. These are not mutually exclusive factors, of course. 26 million are refugees, 45.7 million are IDPs, internally displaced people, nearly twice as many refugees. 4.2 million are asylum seekers, and 3.6 million are Venezuelans who are listed as displaced abroad, a special category. 40%, according to the report, happen to be children. So in previous year's report, actually more than half of the world's forcibly displaced or refugees were in fact minors. 68% originate in just 5 countries: Syria, Venezuela, Afghanistan, South Sudan, and Myanmar. So think about that just for a moment. Why do more than 2/3 of the world's forcibly displaced come from only just 5 countries? In 2010, there were 41.5 million forcibly displaced. In 2015, there were 65.1 million. And today, there are likely well over 80 million forcibly displaced. The trend is steadily upward. In fact, 1% of the world's population are forcibly displaced persons. So how high do you think this figure can go? Ask yourself, how high do you think the ceiling in terms of the number of forcibly displaced in the world can increase to? Is it 2%, 3%, or even more of the world's total population? The top 10 source countries, the 5 previous ones that I listed, plus Somalia, the Democratic Republic of Congo, Sudan, Iraq, the Central African Republic, these are the 10 top source countries. All of these countries, with the exception of Venezuela, have been racked by protracted armed conflict. Now, these wars have been ongoing for quite a while, and they appear to be endless wars. Have we gotten to the point that wars can no longer be soluble? When, if ever, will the cycle of violence, systemic organized violence, end? And I could say perhaps when injustice ends in the world. If you look at the US State Department's Bureau of Counterterrorism that issues annual reports, country reports on terrorism for 2019, it indicates that terrorist networks continue to exploit undergoverned spaces, conflict zones, and global security gaps to recruit, fundraise, and plot attacks. START, which is the National Consortium for the Study of Terrorism and Responses to Terrorism, issues a report on an annual basis. And their 2019 report on global terrorism, it's entitled Global Terrorism Overview, states that there were 8,500 terrorist attacks around the world in 2019. 20,300 were killed, including 5,460 perpetrators, and there were 14,840 victims. Even though the number of terrorist attacks was decreasing over the last 5 years, Afghanistan experienced 21% of the terrorist attacks worldwide, with 41% of the persons killed. And in fact, the number of terrorist attacks in Afghanistan increased by 2%. Iraq experienced more terrorist attacks than any of these other countries that had at least 150 terrorist attacks or more in 2019. So if you look at the list of countries that experience the most terrorist attacks in the world, Afghanistan with 1,804 attacks, Yemen with 771 attacks, Iraq with 642, India with 623, Pakistan 362, Somalia 360, Syria 292, the Democratic Republic of Congo 250, Colombia 228, and Nepal 200. All of these countries have been experiencing protracted armed conflict, as well as, I indicated previously, mass forced displacement. So if you look at the primary source countries for the world's refugees, what you find is they overlap almost directly with the countries that are experiencing the most terrorist attacks. So this clearly indicates that there's a direct correlation between terrorism and protracted armed conflict. So extreme organized violence generates terrorism, as well as forcibly displaced persons, including refugees. So it could be argued, and this is in fact what I do argue in the volume in my chapters, is that terrorism actually accelerates forced displacement. It serves as a catalyst for forced displacement. So, in fact, what I do argue in the paper itself, in my chapters in the volume, is that there is a direct interrelationship among these three key terms or variables: protracted armed conflict, extreme political violence, terrorism, and forced displacement. The genesis for this particular volume lies with a workshop that was held at the University of London, supported by the Refugee Law Initiative, which is based at the University of London, on December the 8th, 2017. It was followed by a publication, a working paper series, a mini volume that is put out by the Refugee Law Initiative. And this evolved into the current project with Brill Ninehoff Publications. I want to start by just listing some fundamental points that you should keep in mind that are very relevant here for our book launch. The first is, you may be surprised to hear, or you may not be, that there is no commonly accepted legal definition for terrorism. In fact, there is no universal definition for who is a refugee. There is no universal legal definition of what constitutes terrorism. There's no comprehensive convention issued by the United Nations, endorsed by states, for what constitutes terrorism. Likewise, if you look at the definition in terms of refugee, it varies from region to region. So there's a different definition under the OAU Convention, the 1969 OAU Convention, that covers Africa. The Cartagena Declaration of 1984 builds on the 1969 OAU Convention and expands the definition of refugee even more. If you go to Europe, Europe has its qualifications directive, which uses the supplementary protection. So if you look at the definition of who is a refugee, it varies from region to region. Now, this obviously has serious implications in terms of policy, as well as creating legal discrepancies in determining who not only is a refugee, but who is a terrorist when you go from one region to another region, from one state to another state. It also has serious implications, of course, for counterterrorism strategies and measures on an international, a transnational, and a national basis as well. Now, in the conclusion, what I tried to do is summarize the key findings of all of the chapters and then lay out a number of recommendations. And I'm not going to list all of the 5 recommendations. You'll have to go to the volume itself to get all of them. But I want to share at least a couple with you. And the very first one is, and I underscore this and try to emphasize it, is the necessity of reaching a comprehensive convention on terrorism that I know it's challenging, that has to be negotiated across all of the states in the world today. But without a common legal definition of terrorism, we're going to have this problem in terms of variance across regions, across states, in terms of who in fact is a terrorist. You could also, I think, make an argument, but I don't think has the same salience in terms of coming up with a common definition of who is a refugee. Now, there are many states that aren't party to the 51 Convention. You have to keep that in mind as well. There are only 148 states that are party to either the 51 Convention and the 67 Protocol. So there are a number of states that are not included in this process. But I think the priority should be on a comprehensive convention on terrorism. And finally, one of the other recommendations I make is those who were excluded from refugee protection on the basis of their direct participation in terrorist activities ought to be prosecuted for their crime of terrorism whenever, of course, the evidence warrants it. And in terms of bringing about these changes, this is really important. And how can we do this? And I will start with saying that all of us have a role to play in terms of bringing about these positive changes. And this not only includes a personal commitment on everyone's part, but also the formation of multi-stakeholder networks that span geographic, institutional, sectoral boundaries to generate systemic changes in terms of the current system. What Steve Waddell calls in his book, Global Action Networks, and he published this in 2011. And as some of you know, the World Refugee Council has actually tried to undertake this and is doing this right now, trying to build a global action network to reform the current refugee process. Now, today we have two contributors to the collection who will present on their chapters, and I'll introduce them in the order of their presentation. The first is Joseph Rikhof from the University of Ottawa. He's in the Faculty of Common Law. He teaches international criminal law. He's also a former senior counsel at the Crimes Against Humanity and War Crimes section within the Department of Justice in the federal government. He's now recently retired from that particular position, but he hasn't retired from the discipline or the field. He's probably more active now than ever. And he's widely acknowledged as probably one of the leading authorities in the world on Article 1F exclusion. And his contribution is titled Complicity in Exclusion for Terrorist Crimes. Our second contributor and presenter today is Selina Marsh, who holds a Master of Arts in Refugee Protection and Forced Migration Studies from the University of London. She is an interdisciplinary researcher and analyzes securitization and criminalization trends in contemporary immigration and asylum policy in the United States. And the title of her talk, which is different from the title of her chapter, is In the Name of the Law, Securitization in Contemporary U.S. Immigration Policy. So I'm going to turn things over first to Joseph Rikhof. Joseph.
Thanks so much for the kind introduction, James. I like to talk a bit broader than the title of my chapter because it is rather technical. I want to talk a bit more about the notions of terrorism and refugee and asylum and how that interacts. I mean, when people typically think about the notion of terrorism, what comes to mind is people who are involved in carrying out terrorist activities. On the other side, when we talk about asylum, immediately people think about people who are victimized as a result of particular acts. And what this book does, it appends a little bit those additional notions in the sense that terrorism, as James indicated, is often also a main contributor to people being persecuted and therefore becoming possibly subject of asylum in countries where they flee to. And reversely, when we talk about asylum, and while it's true that the main asylum conventions, which James mentioned, the vast majority of those provisions deal with in what circumstances people are entitled to receive asylum and what it means to have asylum, like what rights are associated with asylum. However, that part of the convention is not the only part. The convention also have like all of them is small or usually only one article that deals with people who've involved in criminal activities, including terrorism. And I think the strength of this book is it brings together the traditional notions of asylum and terrorism, but also looks at in how far terrorism are a cause for asylum and in how far people who are seeking asylum can be refused that status because of involvement in terrorist activities. In the book, you find, for instance, chapters on how, on the latter point, how people who've been involved in terrorist activities are treated in countries as far and wide as Australia, UK, Austria, Switzerland, United States, and Canada. In my chapter, I try to look at some overarching notions of under what circumstances people will not be given asylum status because they've been involved in terrorism activities. And as James indicated, both notions of terrorism as well as asylum are still a bit nebulous. And while there is on the terrorism side no overarching definition internationally, You can see some trends at the national level where countries have penalized acts of terrorism and have been attempting to define terrorism. You see some trends of coherence in the sense that most of those definitions of terrorism in the countries around the world emphasize two things. One thing is that they say terrorism, for the most part, involves acts of a very serious nature, which either affects lives or personal integrity of people, or involve large-scale destruction of property. That's always one aspect. The other aspect of terrorism that you see a bit of a congruence on is the reasons why people commit those those offenses involving people being killed or injured or property being damaged, because without an additional element, those crimes aren't actually regular crimes on the criminal codes. So what countries have added for the most part is that those serious acts only amount to terrorism if they're carried out for a particular purpose. And the purpose are usually related to the fact that the perpetrator wants to intimidate the population or force a government to do something or refrain something. So those is like, and you see that quite often in terrorist legislation. Some countries also add another mental element by saying that you have to carry it out for a social, political, or religious purpose, but that is not universal. So similarly, when you talk about asylum and the way people are not entitled to asylum because of terrorist activities, those provisions are usually contained in an article that is called an exclusion clause. An exclusion clause means that somebody who otherwise might be entitled to asylum will not be granted that status because they're involved in serious criminality. And the most important exclusion clause is contained in the 1951 Refugee Convention in what's called Article 1F. And in Article 1F, there are three types of exclusion clauses or exclusion provisions. The first one is called 1FA, says that a person is not entitled to asylum if that person has committed a crime against humanity, a war crime, or crime against peace, as defined in international instruments. Article 1FB says the following: a person not entitled to refugee status if that person has committed a serious and non-political crime carried out in a country outside the country where the person sought refugee status. And Article 1FC says a person is not entitled to refugee status if the person is guilty of acts against the purposes and principles of the United Nations. Now, bringing it back to the topic of this session, theoretically, terrorist activities, as I tried to define earlier, could feasibly fall within all three aspects of all three refugee clauses. If a serious attack on people or on property is carried out, and is carried out in an armed conflict or systematic or widespread fashion, that particular activity could very well fall under the 1FA clause of the convention. However, while theoretically possible, most terrorist activities have been brought under, and I say brought under, that usually is done by way of a judicial interpretation of the exclusion clauses. And the ones that was traditionally used, and it seems the most obvious one, is 1FB. If you commit a serious crime outside the country of refugee, and it's also not political, then you are excluded from protection under the Refugee Convention. And then I have 1FC, which is actually being used more recently. As I said, traditionally 1FB was used, but more recently, I'm talking about the last 10 years, especially in the UK and in Europe, continental Europe, 1FC has become the vehicle of indicating that somebody who commits terrorist offenses will be excluded by way of 1FC. And the reason it's being done is not entirely clear, but I think one aspect why governments argue this in refugee hearings, which were then heard by courts on appeal, is that if you use 1FB, you have to show that a terrorist offense in question was not carried out for political purpose. While when this was raised on the FB context, in a majority of cases in North America, Europe, Australia, New Zealand, this political objective was usually declined by the decision makers, for the most part because the means used were disproportional to the objective achieved in this terrorist offense, because most of the time terrorist offenses include the loss of life of civilians, and that brings it very quickly in a disproportionate fashion, and therefore it becomes a non-political crime. So while it can be done quite easily, you still have to use evidence, you still have to make arguments that the crime was indeed non-political. That argument is not even necessary to be made in the 1FC context. So it is just an easier way to get the conclusion for governments to say that somebody has committed a terrorist offense. And that's why I think that 1FC has become more popular. Now, of course, for a matter of interpretation, it is easier to say that terrorism is a serious crime, because if you use 1FC and the terminology used, namely acts against the purpose of principle of the United Nations, is a very broad concept and is not clear what it means. And courts have been inclined to interpret those words quite restrictively. But having done so, the courts in Canada, in the UK, European Court of Justice have to the conclusion that while the wording is broad, it fits acts of terrorism within that broad wording. So at the moment, 1FC is the most used vehicle to find people excluded for terrorist activities. Now I come to the subject of my paper, is namely all three exclusion clauses by using the words committed in 1FA and 1FB, or is guilty in 1FC, makes it clear, and was also the intention of the drafters, that not only people who have been directly involved in carrying out terror activities, but also people who've had direct involvement or were complicit, they also would fall within those parameters. Now, what's interesting is the jurisprudence in Europe, North America, Australia, New Zealand is that for the 1FA, the War Crimes Against Humanity clause, the vast majority of the judicial interpretation dealt with the parameters, like how broad of a circle you need to have to be brought within the notion of extended liability or complicity. And virtually all the jurisprudence to the highest level deals with what it means to be complicit for 1FA. For 1FB and also 1FC, most of the jurisprudence deals not with the notion of complicity, because for some reason, or it had to do like the priority setting of governments, most cases forward dealt with people who were directly involved, who were not like involved on the periphery of crimes. So as a result, you see not as much jurisprudence on what it means to be complicit in 1FB than you see 1FA. So my paper talks then about, okay, what does it mean? What are the parameters of complicity, of extended liability in 1FB? Especially since 1FA and 1FB use the same words to indicate this kind of liability. They both use the word committed. So on the face of it, it should be the exact same parameters. The circle of population should be exactly the same. But my argument is that it's actually not the case, that an argument can be made that 1FB is actually wider. Why do I say that? I say that because in 1FA, there is a a limiting language that makes 1FA narrower than 1FB in my view, because 1FA refers to international crimes as defined by international instruments. And the fact that international instruments has been determined to be international criminal law, it means that if there are areas outside international criminal law which are broader, that means, and they can be applied to 1FB, that means 1FB can be broader. And in my view, there are two sources of interpretation that can be used to interpret 1FB. One source is what's called transnational criminal law, which is the area of law that deals with crimes such as terrorism, organized crime, corruption, arms trafficking, etc. And secondly, you can rely, in my view, on national legislation in the criminal field dealing with terrorism. And looking at those fields, which in my view apply to 1FB, I come to the conclusion that there are aspects of 1FB complicity which go beyond the 1FA, and specifically in the transnational criminal law, there is a notion of issuing threats, which can, in my view, can be used in 1FB. More controversially, but argument can be made, if you rely on national criminal legislation, I compare a number of countries, you see that quite a few countries have gone very far in criminalizing terrorism activities, specifically and especially how they deal with the connection between individuals and organizations. A number of countries have said if you participate in an organization, if you lead an organization, or even if you are a member of an organization, then you are also criminally responsible on the national level. And I think that interpretation can be introduced in 1FB, as a result of which 1FB can be broader than 1FA. Thank you.
Thank you very much, Joseph. We'll now turn to Selina Marsh.
Thank you, James, for the introduction, and Joseph for your contribution. I'll be sharing some slides here, so let me share my screen. Okay, so as James mentioned, my title today is different than my title in the chapter. My title in the volume is Manufacturing Fear, Examining the Social Component of Anti-Immigration Policies Within Counterterrorism Discourse. Today, I'm focusing on a portion of that chapter, hence the different name, and I'm focusing on the letter of the law versus the spirit of the law, and how social strategies can be brought in to influence decisions on the legality of counterterrorism measures related to immigration and asylum. So the chapter centers around critical race theory, which has many components to it, but for the purpose of this talk, one of the most important things to understand is the cycle of cultural, individual, and institutional racism, and how they can feed into and reinforce one another in what becomes a self-perpetuating cycle. Here I have just one example relating to the subject of this talk, which is on Executive Order 13780, formerly Executive Order 13769, which are both titled Protecting the Nation from Foreign Terrorist Entry into the United States. So here, based on that as the institutional racism piece, the piece that is codified into law, we have also the individual racism piece, which looks like hate speech or hate crimes, and the cultural racism piece, which looks like Islamophobia. And looking at just this simple example, you can see how hate speech and hate crimes can fuel Islamophobia, which can then be used to justify legal action against Muslim refugees and immigrants. And then since legal action is put in place, it can be used to point to, in hate speech and hate crimes, or in Islamophobia as justification for why those things do exist. And that is the way that the cycle perpetuates itself continuously. The piece I'm going to be focusing on the most, the pieces I'm focusing on the most are the cultural racism piece and the institutional racism piece, and how those two reinforcing one another. I'll be looking at how the current administration has utilized cultural racism strategies to pave the way for these restrictive policies that were colloquially titled the Muslim ban and the Muslim ban 2.0. But as I mentioned, are actually titled the Protecting the Nation from Foreign Terrorist Entry. And this quote really shows the importance of the cultural piece and how it interplays with that institutional piece. Without a generally accepted cultural norm of Islamophobia, or that Muslim immigrants and refugees are dangerous and represent a threat of terrorism, then the legislation itself would have no ground to stand on. The legislation itself explicitly distances itself from Islamophobic pieces. However, that was mostly in the rewrite of the law, which had been challenged in the courts. And that new language was updated to remove those references in order to have the law pass and be generally accepted by the public. Without that existing cultural racism against Muslim refugees and immigrants, there would be no buy-in from the American public or portions of the American public on which to push this law forward. So a few of the narratives that are at play in the strategies used by the Trump administration and in other administrations around the world are securitization and criminalization. That link with national security and terrorism is one of the most important strategies that's used, because in the international stage, national security takes on an almost carte blanche effect, where if it is justified on the grounds of national security, it becomes a kind of hands-off approach, and it's hard to enforce against it. Another tactic that's used very effectively in the States is nationalism and nativism, this distancing approach and this fear of the other, defining what it is to be an American and what it is to be outside of that concept, is a specific narrative designed to alienate certain people at certain strategic times. We see it a lot in regards to Central American immigration, particularly lately, whereas in the history of the United States, Mexican immigration used to be favored and was exempt from a lot of laws and exclusions because of the representativeness in the American workforce. However, when that started to be characterized as a threat, we started to see more restrictive policies. This also happened with asylum seekers from Muslim majority countries at the beginning of the Iraq War. We accepted more and increasing numbers of asylum applications from those countries. However, since then, there's been a turn where we are seeing decreasing grant rates for people from Muslim majority countries, and we're seeing instances like this executive order that specifically bans immigration and asylum from particular countries, including Iran, Syria, Venezuela, Yemen, Libya, and North Korea. Dehumanization also plays into that fear of the other. It creates a distance between any sympathy that the refugee cases might elicit, potentially, by classifying people as, subhuman in some way. And the one key instance of that is the use of the term illegal alien. Literally, you're using the term alien, which means, not of this world. And so there's a real distancing tactic that happens in just the choice of the simplest words. And then the final strategy that we're seeing is conflation between immigrants and refugees. Blurring that line between those two categories serves an intentional political purpose because, again, it distances from not only any sympathy that might be elicited by asylum seekers, but also from particular legal obligations under the Refugee Convention. Most recently, so sorry about that. Most recently, we had a memorandum on September 4th, 2020, which was directed specifically against critical race theory, which, as I've said, is the basis of this research and other similar research of this kind. A few quotes from that memo are extracted here and provided, and you can see that this one was specifically targeting training, critical race theory training among federal contracts and organizations. And they classify critical race theory and white privilege as propaganda and un-American propaganda at that. They also make a point to emphasize that the president has a proven track record of standing for those whose voice has long been ignored, when we have seen a very divisive presidency, in fact, and we've all heard the rhetoric that comes out of that administration when it comes to immigrants of any kind. And so this is a cultural racism strategy in the sense of that othering and defining what it means to be American and also un-American based on political purposes. We also have a few tweets, our president's preferred method of communication, that emphasize another cultural racism strategy, which is stoking fear of the other. We saw these all during the election and soon afterwards. And there's a characterization that the legal system is broken, there's a breakdown in law and order, and that it's a national security issue. So that again sets the stage for the kind of policies that are being passed by the administration. And so this is where the cultural racism plays into the institutional racism, is in codification of these norms. One important one is Security Council Resolution 1373, which codifies in international law a link between terrorism and asylum. That has since been used to justify domestic restrictive policies, including these executive orders, which pull from the same kind of well when it comes to justifying the need for them, about this idea that the asylum system is being exploited by terrorists or potential terrorists to enter the United States for nefarious reasons. And so there's a lot that comes out of that, but really it's this codification that cultural racism can point to as justification of the fear of Muslim immigrants and refugees. And here we're going into the core of this particular talk, which is the letter of the law versus the spirit of the law. All of these quotes are taken from Supreme Court decision on the executive order, the second one, which had been rewritten, as I said, to exclude any mentions to Islamophobia or religion in general. And on the left, you have the majority decision. It was a split decision, 5-4. And you can see that the argument is that the proclamation is expressly premised on legitimate purposes, legal purposes, that purpose being national security. And as I previously mentioned, when national security is invoked, especially here in the US, it has this carte blanche effect where it is not subject to as much litigation or pushback necessarily as the law might have been if it had not invoked national security as a concern. And here we kind of have this idea of the tyranny of law and order, and how law and order is often used as a justification for restrictive policies, and this idea of a breakdown of law and order when it comes to admitting refugees from Muslim majority countries. And so that narrative can be changed depending on the cultural circumstances of the time and the political uses that the administration desires at any given time. And this has been done throughout the history of the US, this current administration is certainly not the only one to use these tactics. On the right, you have a quote from one of the dissenters, which brings in the rhetoric of the Trump administration and Trump himself, and notes that there's no way to ignore the fact that this is discriminatory and that it was updated from version 1 to version 2 to try to cover up that fact, but that it absolutely exists and it should be taken into account. And here we kind of have a battle between different legal interpretation methods. On the right, you're using critical legal studies and critical race theory, which looks beyond just the letter of the law to look at the context that shaped the law. And on the left, you're having a more traditionally legalist interpretation. I also noted on the right that in the Global Compact on Migration, Objective 17 notes an attempt to eliminate all forms of discrimination and promote evidence-based public discourse, which seems to be a clear rebuke of the type of strategies being used by this administration and others around the world. And this all kind of goes into the fact that when there is high anxiety, there is less tolerance. The administration in particular has utilized and exploited the American fear of terrorism, which is a very salient one, despite our somewhat limited exposure to it compared to other countries where it's much more common. In a survey of American fears, the fear of terrorism or terrorist-related attacks ranked 2nd and 4th in the top American fears. So this kind of fear-mongering is targeted to those people and emphasizing that sort of rhetoric and narrative. And so looking briefly at the impact on international refugee protection and broadly, we're seeing an increase in detention policies for asylum seekers here in the US. We're also seeing an increase in the use of screening and surveillance technology, including facial recognition software and software that analyzes video feed to estimate who might be a threat. Obviously, these algorithms are not in any way neutral or non-discriminatory because though based on algorithms, they were coded by people who have inherent bias. And that threat of inherent bias also comes into refugee status determination proceedings. The idea that anyone from a particular country might be trying to enter for nefarious purposes is something that they then need to push back against in those proceedings, on top of proving a refugee claim. And then there's the skirting and undermining of legal obligations, which is not only limited to legal obligations on asylum. It's a trend of this administration and somewhat of the US more generally. And that is a big concern when it comes to things like the Global Compact on Migration or anything related to refugees in international law, because there are big players in the game who are pushing for more restrictive policies, and there are other countries that are looking at that to model after and therefore are supporting those restrictive narratives. And I'm closing with this, which kind of sums up that relationship between individual, cultural, and institutional racism, and talks about how this mob mentality doesn't just appear out of nowhere. Policy is not created in a vacuum, and all of these things come into play when it comes to both framing the law, writing the law, and passing the law, and then to any litigation or arguments against the law, as we saw in the Supreme Court decision on the executive orders. Thank you.
Thank you very much, Selina. We have some time now for questions. I know we started a little later, so I'm going to beg the indulgence of the people who are present to go on a little bit longer to take questions. So I'm going to open the floor for anyone who would like to pose a question to any of us. So you can unmute yourself, I think, or raise your hand and we can call on you to ask a question. Well, I don't see anyone raising their hand yet. Maybe I can pose a question to our panelist here today. Joseph, you talked about exclusion under Article 1F. And I believe you said at one point that you thought in terms of terrorism, Article 1FB might be better suited in terms of excluding individuals. Is that correct?
What I said is that, I said two things. The first one is that countries in the last 10 years have used 1FC more often than 1FB to categorize terrorism as part of exclusion. The other thing I said is that it looks like to me that if you look at the parameters of complicity, that 1FB could very well be broader than 1FA, because 1FA has this sentence that has been interpreted according to international law. And if you compare international criminal law, you compare international criminal law and its concepts of complicity with other areas of international law which are relevant, like transnational criminal law or domestic criminal law, you find a number of instances whereby the other areas of international law or domestic terrorism legislation have made people part of complicity broader than has been acknowledged so far in international criminal law.
Yeah, I thought you provided an excellent analysis in your chapter. Obviously, you didn't get an opportunity in 15 minutes to cover everything in your chapter, but I think you did a wonderful job of looking at extended liability in international criminal law and comparing that to the jurisprudence in a number of different jurisdictions with respect to people who have been excluded on the basis of terrorist activity. And you come to the conclusion that international criminal law has a broader, more extensive liability than under international refugee law, or at least in those states that you looked at. But the counter argument to that might be, since refugee status is a humanitarian thing, shouldn't it be more restrictive in the sense that you should be giving people the benefit of the doubt? So having a broader extended liability in international criminal law is fine, but when it comes to refugee law, perhaps it should be more limited. What do you think about that argument?
Yeah, and that's a very fair argument. I mean, there's been a number of writings that explain that the way the courts have interpreted extended liability complicity in refugee law by relying on criminal law has its problems. And I agree. Like, one problem, for instance, is if you find that somebody is excludable because of the fact that the person has been involved in activities and the person did that because of external pressure, if that external pressure, like influence or undue influence or pressure, and that the pressure does not reach the level of a defense like duress, then the persons in refugee law are out of luck. While in criminal law, international criminal law, domestic criminal law, you actually have other means. Like in criminal law, if somebody might still be guilty and has not a defense, then the sentencing portion will be used to say, well, yes, you did it, but here are a number of mitigating circumstances, so we will not give you as much of a sentence as you would have gotten if you had no excuses. That possibility is not present in exclusion law, and that is a big problem. The other problem is is that the standard of proof, like the kind of evidence you have to bring forward in a criminal trial versus exclusion proceeding in criminal trial is much, much higher. Is expressed in the words beyond reasonable doubt, while in the exclusion law it's much lower. That's been said a lot, and I do agree with that. What is not said very much, which has to be used as well, is the type of evidence. It's remarkable that you can't find someone excluded on only two types of evidence: the person's own statement, and as corroboration, you use human rights reporting. You will never get away with that in criminal trials because you have to have witnesses, you have to have experts. So there are a number of aspects where it's much easier to find somebody excluded or guilty on refugee law than it would be in criminal law. Although courts have increasingly relied on criminal law concepts to direct what the meanings of the crimes are and extended liability. So those are indeed problems. And I do agree with you that if you look at the fact that the Refugee Convention is a humanitarian instrument that should play a role. And when I talk in a presentation about that the notion of complicity based on national legislation, and I looked at 10 countries, look at the legislation, and I found over 40 types of forms of extended liability, from directly involved to membership. So on one hand, I do think that the exclusion process is a whole lot less robust than criminal law. On the other hand, because of some of the effects that Selina pointed out, countries in Europe, in North America, in Australia, New Zealand, people, legislators, and courts are much more inclined nowadays, since 2001, to use those narratives and give a very broad interpretation of what are terrorists. So you see a hardening of positions in criminal law, in international criminal law, in transnational criminal law, in refugee law, and especially immigration law. Like most countries, when they do not look at refugees or asylum seekers, but immigrants, they have no trouble giving people no status if they only are members of an organization. So you see a number of trends which converge, and all can be worrisome in terms of human rights. My point is that while the Refugee Convention is a human rights convention, the fact that the trend is carried out there too is not unique, as you see it as part of a much larger way that legislators and judges are reflecting societal concerns, and times have gone too far.
Selina, I have a question for you as well. Given Donald Trump is a populist leader, if you will, and president, who is quite divisive and it intends to really exploit, if you will, the divisions within the United States for gaining political office. But given his ideology and his approach to things, once he gets into office, he undertakes these kinds of measures, like you said, the Muslim ban 1 and Muslim ban 2 and so on. Do you see any positive changes likely during this election campaign? And is there a possibility that perhaps this will end? And I'm sorry for the distortion, at least I'm hearing it.
So in short, no, I don't, unfortunately. But one of the reasons for that is you can see the same kind of rhetoric that was used in the 2016 election already being used in the 2020 election. You also are talking about an administration and president that doubles down even harder when pushed against. And so I think that more likely than not, these trends will continue, if not get worse, if we see another 4 years of the current administration. And, you know, we started with the Muslim ban 1, Muslim ban 2. We moved into the family separation policy that impacted immigration coming in from Mexico. And obviously, a lot of that was Central American migration. Even in justifying that policy, the vice president went out and said and tried to claim that there was evidence of terrorists trying to enter through Mexico, Muslim immigrants entering through Mexico, which factually there is not evidence of that. So you have an administration that is not only willing to put out and shape these narratives, but is also willing to bend the truth to support these narratives, because they're speaking to a base that will believe these narratives and is already inclined to believe these narratives based on their existing fear of terrorism and Islamophobia.
Sorry, James, you're muted right now. You'll have to unmute your microphone. We can't hear you at the moment.
Yeah, sorry. I thought I did. I'm just wondering whether or not you see any possibility for the Biden-Harris ticket now, particularly with the pandemic and the gross mismanagement and incompetence of the current administration in dealing with the pandemic in the United States, with now over 200,000 people dead.
Yeah, absolutely. I see some potential optimism there, mostly because you're looking at a very experienced politician and legislator in Biden, and one who worked with the previous administration. And you're seeing in Harris someone who has, on the opposite side, a securitization kind of mindset from her political experience to date. So you could have a mix. It kind of depends on how much that administration would want to push off against the other. We're living in very divided times. And you also have to take into account the fact that these policies can be challenged by the Senate, which is majority rule by the other party. And that was one of the things that kind of hamstrung the Obama administration in many of its years, was that divisiveness has gotten so bad, that polarization has gotten so bad, that to even talk of bipartisanship is blasphemy these days. And it used to be the norm that, okay, there's going to be division when the election is running, but once that person takes office, they are supposed to be a unifying force. We're seeing movement away from that, and we are seeing, you know, something that did not necessarily start with the Trump administration, which is the overuse of executive orders, and that kind of use of presidential power in a way that it shouldn't constitutionally be used. But unfortunately, those kinds of decisions are adjudicated at the Supreme Court, which is also politically divided, although it should be neutral in theory.
Well, I hope you're going to go out and vote.
Absolutely.
Along with all of the other citizens in the United States. Are there any other questions that people might have or comments?
I have one question, James, for both our members of our panel. Earlier in the year, before the coronavirus took over the news cycle, I had read an article about where Donald Trump was sort of publicly musing the idea of considering Mexican drug cartel, labeling Mexican drug cartels as terrorist organizations. And as I understand it, if this happened, it would make it much easier for individuals who live in regions where there is a high amount of cartel activity to apply as asylum seekers to enter the United States, and therefore it would be easier because they could simply walk up to a border official, present themselves, and say, "I'm seeking asylum. It's because of these terrorist organizations." I'm wondering if either of you think that such a designation would be appropriate in under the circumstances.
Want to go first, Selina?
Sure, I can go. So I think that's a really interesting question. And I think what it comes down to is American asylum policy has been used in multiple ways kind of throughout the years. And one of those ways has been to call out particular organizations, groups of countries, or individual countries. For instance, during the Cold War, we accepted and encouraged applications from former Soviet bloc countries. And part of that was a condemnation of those administrations. And so here you're kind of seeing condemnation of not only these drug cartels, but also the countries that allow them to flourish in the viewpoint of the administration. And so really it kind of has to be taken in with the full context, which also includes the Remain in Mexico policy and the family separation policy, that zero tolerance prosecution policy. So at the same time as you're saying, okay, we'll accept you as asylum seekers, you're seeing more restrictive policies that kind of prevent that narrative from actually being true. So my take on it is just that it may have been speculatively used in this way of making it easier for asylum seekers, but really below the face of it, it ties in with a lot of the other restrictive policies that we've seen.
Thank you.
I'm not as familiar with US law as Selina is, but if we talk about Canada, in some respect, the United States, in general, if somebody wants to claim asylum, they have to show that they were persecuted. And of course, there's a whole body of jurisprudence, what it means and what circumstances and things like that. But it seems to me that if you are facing or fearing persecution from a group, whether it calls itself or is being called terrorist or organized crime, doesn't make a difference as long as you meet the levels of persecution, apart from all the special programs that might come and play. On the other hand, from my perspective, I'm looking at sort of the exclusion aspects. If somebody who like belongs to an organized crime or to a terrorist group, and they come to the United States of Canada and they're going to look at whether they can actually give asylum in spite of their activities, what you find a lot is that those nomenclature of organized group, organized crime, terrorist crime, they are given by government organizations, international organizations. Those groups themselves don't organize themselves along those lines. They just go where either the money is or the ideological objective is. And it's very common that there is not only the fact that groups can be engaged in both activities, organized crime and terrorism, but often you see also that groups which on the face of it are organized crime versus terrorism, they support each other. It's not uncommon that terrorist group get financed by drug cartels. So this distinction is to some respect a little bit diffuse and on both sides, for the persecution side and for the exclusion side. I mean, there are distinctions, but in terms of how you apply it, from my view, to be very simplistic, if you are persecuted, it should not matter by whom, as long as you meet the standard. If you are a criminal, I mean like a real criminal supporter like that, it shouldn't matter whether you belong to organized crime or terrorist group. You have, like on the 1FB, you are a criminal on the either category, and it has been said in jurisprudence, because what both groups do is still engage in serious criminality. No matter that you might distinguish slightly what those criminalities are, which are not really an issue in the immigration or asylum context.
Thank you both.
Yes, I think we've expired our time, so I want to take a few minutes just to thank Selina Marsh and Joseph Rikhof for their presentations, and again, personally, for their contributions to the edited volume. Obviously, we can't cover the rich detail that you can find. As Selina indicated, she only could present on a portion of her excellent paper, and likewise Joseph could only touch on his paper, and I recommend that you take a look at those. And hopefully the book will be available in the library and in electronic form. I also want to thank everyone for their participation in our virtual book launch here today. And I'd like to also welcome all of you to join us for future McLaughlin College Lunchtime Talks. We have one coming up next week on September the 30th, which is geared for all of the students, specifically for all the students here at McLaughlin College, but also in other colleges across the university. I'd like to remind everyone that we're also doing a virtual book launch for our European contributors who weren't able to join us here today, and that will be held in the morning on October the 7th. So if you're interested in this particular subject matter, but dealing with different chapters in the book, there's some excellent chapters that cover a wide variety of different concerns. So if you're interested in this, please join us for that. And students who attend 6 talks during the course of the academic year receive a certificate from us. And if you attend 10 or more talks, you receive the honor certificate. So please keep that in mind. That always looks very good on your CV. Or if you're applying for professional schools or graduate schools, it also looks very good on your record. We also do a random draw for book prizes for attending these lunchtime talks. Please visit our website, our college website, for more information about all our upcoming talks and activities. And as we all know, we have to prevail online, remotely. So all of our student services and college activities and events are going to be held virtually this academic year. So take full advantage of all of the upcoming events and visit our website to keep informed about those activities. So thanks again, everyone, and hope to see you at future events. And I'm going to sign everyone off at this point. Thank you. Bye for now.